Welcome to The Law, Your Money, and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts.
And I'm Camille Barron, a financial coordinator and health insurance advisor in Massachusetts. And today we have someone who's never been on the show before, but we're very excited to have her.
And why are we so excited?
Because
Because she's an attorney? No.
There's more than that.
Is it because she's in estate planning? No. Is it because she's in asset protection? No. It's because her name is Deborah Danger.
And
Yay!
she's dangerous.
Yes, welcome. You have to tell us a little bit about yourselves, and sometimes what happens, we get more in the other part of the person than the professional part.
Yeah.
And you are so fascinating.
You are so flattering. Well, so my name's Deborah Danger. I started out, I went to study finance in college, but I picked my college based on the drinking age of the city in which it was located. So I didn't really pay attention.
You've got to be kidding. We
so-
should have changed
That should be the end.
Yeah, that's
What
the
city
end
was
of
it in?
I went to Washington, D.C.,
Which,
which at the time they were changing the drinking age to 21, and they offered to withhold federal highway funding if states didn't raise their drinking age to 21. But since the District of Columbia is in a state, it didn't have any federal funding.
Good choice.
So they kept the drinking age at 18.
So we just learned something new. I want to have our viewers know the background in your name, if you don't mind.
Sure. So
Great.
when my background is Lithuanian, and my family name is Lichkauskas, and when my family came over, it was changed to Luki. And in 1995, my life partner was diagnosed with very aggressive breast cancer. But through a number of experimental treatments, she lasted until 2003. And it was a very like living on death row was kind of what was going on. And so because of all the extraordinary things we were able to accomplish together, and that I did for her, she called me Debbie Danger. So when she died in 2003, I was very sad, and we couldn't get married at the time. So I wanted to take a piece of her with me. So I legally changed my name to Deborah Danger. I went to the court and I said, I'd like to change my name. And the morning of the first day of law school, I got the judgment in the mail. So I went to school and I changed my name to Deborah Danger. So from the first day of law school on, my name's been Deborah Danger.
what a story.
It's a great name, great story.
Yep. And so every time someone calls me Deborah Danger, I think of her, which is like inspiring. Because she's why I went to law school, because at Dana-Farber we couldn't marry, and we didn't know about estate planning documents. So it was really just them honoring our relationship that allowed me to be as involved and informed of what was going on. So.
And where did you live at the time?
We lived in Brighton, right around the corner from the Brigham, which is where she got treated.
Oh, in Massachusetts.
Yeah.
And were you an attorney then?
No, not at all. I had my MBA. I went to Babson and got my MBA because I was interested in their international program. I was very interested in how to run a business because, as I said, I was busy doing other things in college, but I was still interested in finance. So I went to business school and pretty much took all the same courses, but at the graduate level. I found them so fascinating because I wasn't really paying attention, the first time. So I got my MBA and was doing real estate investment and a lot of Excel spreadsheet, modeling and investment, internal rates of return, managing tax losses and things like that. So I was doing tax, and then when I went to law school, I thought I was going to be Perry Mason and do whatever I wanted to do, but I really liked the tax piece. So while I went to school at Suffolk, but Georgetown had a joint JD Masters in Tax program. So I applied and went to Georgetown, but by the time I got in there, I'd had more credits at Suffolk, would have had to start again. And I was old, went to school at 43, so I got my JD from Suffolk and my LLM from Georgetown.
One of the things that we were interested in was, it says you were the youngest woman in the history of New Hampshire to be
I was
sworn
not.
in.
So here's the
No?
thing, I was like the oldest person. So all
You were
through
the
law
oldest
school,
one.
I got the message, because I was 43 when I went to law school, and I got the message that I might be too old, that firms didn't want me, that I might not have the stamina to pass the bar exam.
You're
and
kidding.
I got that a lot at Suffolk, but I got it more at Georgetown, because Georgetown's all about big law and going to a firm, and I never wanted to. I went to Babson for entrepreneurship, and I went to law school so I could hang my shingle, and so big law was not important to me, but it kind of wore me down.
Oh, that's
so
terrible.
well, whatever. It is what it is. But my, I had a classmate who was in my law school section who was, I think she was 19 when she started law school. And so she was 21 when she graduated. And I thought, what if the oldest person in our class and the youngest person in our class partnered together?
Yeah.
And we helped each other study for the bar. We didn't take a prep course. We helped each other. And so that was kind of a good fusion point. And we formed a law firm. She was from New Hampshire, but had passed the Massachusetts bar, and I was in Massachusetts. We had an office in both locations, and we didn't have any clients. It was mostly just, I would drive to New Hampshire, or she would drive to Massachusetts, and we'd get together and giggle.
So nice.
But after a year, our practices kind of took off. She got pregnant, and she stayed in New Hampshire. She's still in New Hampshire, and I'm in Massachusetts. But it helped both of us kind of launch our practices and get oriented.
In a relationship.
Stuff like that. Yeah.
Yeah, I found that it doesn't matter how old you are or where you are, and probably the older you are, the better, because they figure
agree
your
now.
seasons.
Yeah.
Because who asked we went to law school?
Right. I have a lot more wisdom.
when?
I had a lot more wisdom then, and now I have a lot more wisdom around that particular issue.
That's nice. So what are you're into estate planning now?
So I started doing estate planning because I was old, and it was interesting to me, and all my friends are old, and I thought I'd be interesting at a cocktail party if I could talk about wills and trusts.
Excuse me, when did you find out that you weren't old?
I don't feel old, but I say I'm old just because I feel like most of the people I hang out with are younger than me, but whatever. But I feel like it gives me some authority if I say I'm old, because I know what I'm talking about.
Yeah, that's a good point.
So I started doing estate planning because it was personally interesting to me, because I was on my way to, retire, hopefully, or at least get things wrapped up. And I would get a lot of people who were recently divorced, and they would come to me with these awkwardly drafted separation agreements. For example, the one that inspired me said, life insurance money is to be held in trust until both children graduate from college. And I said, I can't help you, because what happens to the money if it's in trust and both your kids neither kid graduates, or only one kid graduates from college? Like, I don't know.
Oh, they didn't.
What if they both become policemen? Like, I don't know. So I said, it's not worth you going back to court and getting an order to change it, but just so you know, I can't help you with that. So I thought, I might be able to do that. Okay, so I found someone who mentored me, and I got into divorce, which brought me into court. While in court, because of my estate planning background, a couple people tapped me to do some probate litigation, which is a will or a trust that fails or is unclear. So I did that. That actually made me a better drafter, because I could see some of the problems that would arise. And then from there, when I started as an undergrad, I was a nursing pre-med student because I thought I was interested in that, but I enjoyed business much more. But because I was doing probate litigation, I got asked to do some guardianship and some conservatorship work with older people, which is a good, you got the estate planning and things like that. So, plus I have the LLM in tax. So I think of my practice as more asset protection, whether through estate planning or divorce, which is all about, particularly late in life, you've got assets that now you're splitting in half. That's like decimated to your savings.
Stop right there, because we don't want to confuse people. Let's just concentrate on asset protection, which is part of estate planning and the drafting and that, because you got to find out what assets you have, what you want protected, and how you're going to go about doing it. So why don't you just give us a little example, concentrate on that, and then we'll...
So when I ask my clients, everything I ask my clients to do, I do. So I think of when you're getting ready to protect your assets, you need to think about your estate, which is if you're incapacitated. Now that we're all living to be 150 years old, we're not probably going to get hit by a bus. We're probably going to be disabled and linger. And so having documents in place that allow someone to make healthcare decisions for you when you can't, someone to manage your finances when you can't. And it's more than that. It's someone who can negotiate with your health insurance company or your car insurance company if you're in an accident. Or
are they the healthcare proxies? Because there's different instruments.
So the healthcare proxy makes decisions. And then the power of attorney is a document that allows people to do everything else. But I like to highlight that it's not just balancing the checkbook and paying the mortgage. There's a lot of administrative stuff as well. And then there's the will, which speaks of death. So that allows you to identify who gets your stuff, who gives your stuff away, and who can be a guardian for your children, whether it be for your actual children or your children's property. And a lot of people come to me and they say, well, the only problem is we can't agree who's going to be the guardian. She wants her sister who's a nurse. I want my brother who's a whiz on Wall Street. And I say to them, good news is you don't have to agree. All you have to do is eat your vegetables and exercise. Because if you outlive your spouse, you get to pick. So it doesn't have to be in concert. So if what's preventing people from making a will is they can't figure out who's going to be the guardian for their kid, I'd like to uncouple that and just say, whoever you want. Hopefully you'll never ever use that clause. But it's good to have one if you do.
You know what I did? We couldn't decide when our kids were little, but we knew that we didn't want one of the mothers to get them. So we picked the least harmful one on one side and the least harmful one on the other side, and said that they have to agree. And again, we forgot to, we made this big thing, and we went away on our trip, came back and saw we never signed them. but the kids are all grown now, so.
Well, I will say two things about that. First of all, I feel like your will is a letter to the court. It's really the only, your voice, if it gets to that. So I'm a big fan of stating who you don't want in addition to who you are actually nominating.
Well, that's very good.
And I would say, while I think that your solution is brilliant, I also coach people that typically if you name two people, usually there should be consensus. And so if there's not, that means something doesn't happen. So for example, if one mother wanted to buy a Maserati and the other mother wanted to buy a Toyota, your kid might not end up getting a car if there's no consensus. So accounting for that, I think, would be important. Maybe not for kids in general, but sometimes when difficult decisions are being made, which is why in Massachusetts, the law states you can name one healthcare proxy at a time. I can't name all 5 of your kids because it's going to take too long to take a consensus in an emergency situation. It's just not productive.
Do you believe more in wills or in trusts? Because
I'm a big fan of
confused.
trust. I will say that, so I think about trust as a will supplement.
Is that a revocable trust or irrevocable? And tell our viewers the difference between the two.
So it depends on your situation. I think a revocable trust is a wonderful thing because, as I talked about your power of attorney has an agent that authorizes people to step in your shoes and effectuate transactions on your behalf. There's nothing in the Mass statute that holds someone accountable if they don't honor the power of attorney. So if I go to Bank of America and I say, Roberta's impaired, she needs money, I have to pay her mortgage, Bank of America is going to say, nope. Our exposure is greater if we give you money erroneously than if we don't. But Roberta's going to incur late charges and maybe foreclosure fees. Too bad. If we don't make a mistake, we're not culpable. So it's easy to deny an agent the ability to do their job. If you have a will, the Mass statute requires that it be probated. And probate is a legal proceeding where we take an asset in the name of someone who's no longer living, and with court supervision, we put it in the name of someone who is. By statute, it can't happen faster than a year because creditors, hospitals, ambulance, American Express, the IRS, all have to have an opportunity to file claims. If you have a trust, like for example, I would say, let's do a trust for you. I'm going to have you give all your stuff away. And you're going to give it to yourself, but as trustee. And that's a tiny change as far as how you control and manage your assets, but it's significant legally, and here's why.
Well, before you say that,
Yeah.
does the trust then have to make out a tax return, or can it still be your own tax return?
It depends on the type of trust. If it's an irrevocable trust, as I said, it's a small change. So this trust, as long as you're alive and have capacity, you can change it. And so it's more or less like a pass-through.
Oh, okay.
So for example, if you have a mortgage on your house, in your mortgage documents, you said, I promise not to transfer this mortgage to another person or entity. And if I do, I violate the terms of this agreement, and I agree that my mortgage will be due, it will accelerate and be due on the date of transfer. There is a federal statute called the Garden-St. Germain Act that says unless you do it, the transfer is from you to a revocable trust for estate planning purposes. Then you're exempt from the due on sale clause that I just described. So it's a very tiny change. It's essentially a name change. You go to the bank and you say, I want to change my account from being in my name to my name as trustee. Everything still runs through your social security number. Your tax return won't demonstrate anything. But one of the most significant benefits that you gain is it's impossible to be the trustee of your trust and therefore the owner of your property and dead at the same time. So when you pass away, your successor, whether it be your spouse or your child or your friend or your accountant or whoever you name, steps into your shoes. So therefore, your spouse owns your stuff as trustee of your trust. So therefore, a dead person doesn't own your stuff. So therefore, we don't have to get court supervision to transfer it. We don't have to do probate to put it in someone else's name. So arguably, you could pass away in the morning as trustee of your trust. We could be very sad. But then we can start giving your stuff away in the afternoon because your successor trustee now is alive and owns your stuff. So that's avoiding probate and facilitating the transfer of assets is a significant benefit to a trust, which is a will supplement, because you still need a will. You still need to appoint someone to manage your affairs when you pass away, because there might be a final paycheck. There might be a final tax return. You might win the lottery the night before you pass away, and there's money to administer. But I typically name the trust as the beneficiary of the will, so that everything goes in your trust. Your trustee has control of everything, and everything is facilitated.
What about, we could use a few more hours.
Oh,
but
yes.
What about, like you're talking about asset protection. Now, I know some people will deed their property to themselves and their son, and then, or their daughter, and then think that when they pass away, the son will sell it and split it with the rest of the kids.
So I have some concerns about people, because you're right, people think that that's a terrific thing, but I will say, if you transfer your property to your son, a couple of things. It's now your son's property. So if your son gets divorced, files bankruptcy, hits Tom Brady with a snowball, and Tom Brady now can sue him for lost wages, that property is vulnerable to the activities of your son. The other thing is if you gift it to your son, let's say, which is not uncommon, you bought your house for $1 because it was cheap back in the 70s, and now it's worth $1 million because it's worth a lot. If you gift your house to your son, you gift him the basis that you have, that $1 that you paid for your house. Now your son is perceived to have bought it for $1. If your son sells it the next day for $1 million, he has a gain, a capital gain of $1 million. Let's presume the capital gain rate, state and federal, is 20%. He now owes $200,000 to the taxing authority. If instead you held that property and you pass away and you leave it to your son via trust or will, he gets what's called a step-up in basis. The step-up in basis is the value of that property goes from $1 to $1 million, whatever the value was on your date of death, to $1 million. Then when he sells it the next day, he sells it for $1 million, he has no gain. So asset protection might seem like a good thing because you're getting things out of your estate, but one form of asset protection is to keep it so you get that step up in basis. I would also caution, many people feel like that's a good idea, as you said, because we expect the son's going to give it to the other 5 children.
Yeah, they don't.
That puts a lot of burden on the son because now he's gifting things away. Maybe he won't do it. A lot of times people have, a couple of kids that come over every day to take care of them and give them meds, and a couple of kids in Ohio that never come to see them, and there's some disfavor amongst kids like that. But I feel like there are other ways, like a trust, that you can transfer the property to, retain control, because that's the other thing. Your son, now you have to consult your son if you want to get a mortgage, if you want to get a roof. He's an owner. You have to check with him.
We used to say, he who visits last gets the money.
Yeah. Now, what happens if, let's say in the case that there might be 5 children, and the one child that's supposed to be the executor in a will, or suppose he or she is not adhering to those things after the principal dies.
So that's the benefit of using a will, is you have indicated what you want to have happen. And it gives all of the children, not just the one who you've appointed, rights. So he has rights because he has responsibilities and he's a beneficiary. And the other 4 who don't have the same responsibilities also have rights. That's what probate litigation is. It's enforcing and trying to interpret what the person wanted, because it's not always clear.
They call it a personal representative now. But what if the aunt put the property in trust, and now it's in trust with the nephew or son or whoever as trustee, and he's supposed to divide it and sell it, and it's right in the trust and never does? You must see those.
There are a couple of things. So one thing is, if no one actually opens a probate, let's say you will, no one opens a probate, but you owe MasterCard $20,000. MasterCard can open a probate for itself. I mean, that happens a lot when you go into a nursing home and you owe the nursing home a lot of money, and no kid is going to open the probate because all the money is going to go to the nursing home. The nursing home is allowed to open a probate
That's interesting.
and get paid, and then if it wants, it can appoint a successor, personal representative, or executor to finish up the estate or not.
So it isn't necessarily litigation at that point.
Right. There are different options. That's true. And if a trustee does not, trustee has what's called a fiduciary duty. Trustee has to put the interest of the trust beneficiaries ahead of his own or her own. So if they're not performing, there's usually a clause in the trust that allows the beneficiary, sometimes through a majority vote, to eject the current trustee and appoint a successor trustee.
Fascinating. With that few minutes we have left, can you probably summarize the best asset protection, like 3 things, or 2 things, or 1 thing, or what's the most important thing?
I would say the best asset protection is to go see an attorney. You know, there are a lot of things online that you can go to, and you don't know whether they work or not until it's too late. Like, you're dead, you can't change it. So seeing an attorney who helps you understand that there's, in addition to an estate plan, I have people do a financial plan, because I want to know how much it costs to be you. If you're going to retire, we need to know what your expenses are. We need to know if your savings can support that, or if a part-time job can do it. There's also a health plan. We should be walking more. We should be, like, there's no point retire if all you're going to do is sit on the couch, let your joints lock up and watch, NCIS from start to finish. And then also an activity plan, because you're going to have this huge vacuum when you retire. So how are you going to fill that? So for me, that's how you protect all your assets: your body, your soul, your mind, your money,
good
and your family relationships. Because if you have well-drafted documents, you won't be in that kind of black hole of people not knowing what they should be doing.
That's very
interesting.
I like that perspective a lot. It isn't just financial assets or property and so forth.
At the beginning, you had all these "you've got to be kidding." By the way, this is the last bag I can find that's in perfect condition.
That's because we haven't used it.
Yeah. Well, the last one that was in perfect condition, as I opened it up, it started to rip, and I don't know where that one walked away, but I'm sure it'll come back. But you've got to be kidding on so much, So you do the you got such a fantastic background,
and it's all tied together. That's
I know,
that's
isn't that crazy? It just kind of
estate
organically
planning,
grew.
asset protection, all this all fits
got
together.
To be kidding.
And that's more than we usually see.
Well, thank you. I appreciate that.
I think one of the first things when people hear your name, they go, "You've got to be kidding."
That's probably true.
But we know she's dangerous now.
Yeah,
So
we
it's
know
a
she's
name that fits
dangerous.
well.
Danger. What a good comic strip. We ought to feature you in our book. Police officers are our
Oh, that
friends.
would be awesome.
Yeah.
That is so cool. That's a great
With a
idea.
police officer. Yeah.
Nice.
Isn't that great? But we thank you very much.
Thank you for having me. This was
I-
very fun to meet you both.
I'm like I'm at a loss for for words because you like have the whole package, business, the planning, and you put the planning in a unique way because you put it to take care of the medical, which is what she's into now, the medical, the insurance, the health, not just the law.
Right. Yep.
Yeah, and you really think about it, all those aspects are important, and you have to
Right.
consider them all together. You
Especially
can't
today.
separate them.
Yep. And I will say, I give a 5% discount to any client that makes me laugh.
Oh yeah, I saw
guess
that. I
that-
was looking for that.
So I feel like that kind of balances the grimness of the work.
What
with,
if,
and
they make you laugh
they go to
30
court.
times? Do you end up owing them money?
See, she laughed. Okay, so if we become our clients,
Right, exactly.
we
Not
have
hard to
evidence
make me laugh.
we have the evidence, it's recorded now.
Exactly.
Well, this is just
This is
great.
fantastic.
It's
Thank
just
you.
great. I
Yes.
mean, it's like you've been around for a long, long time. You're a special kind of attorney, special kind of person that you see the whole package, and we thank you. And Camille's going to wind up and she'll say some nice things about you, and then we go point.
Yeah.
Okay,
So,
all
again, this has been fascinating.
Yeah,
I think there's a
really.
lot more now that we would like to know because we
Good.
just learned some things we don't know.
Good teaser.
Yes,
Yeah.
very
And we
good.
thank you for changing around your schedule, and she just didn't happen. We had to go here and there, and it was a dangerous journey getting Debbie Danger.
You got to be kidding.
Yeah.
So to
No,
our
she's
viewers,
wonderful.
Debbie, thank you very much. I'm
pleasure.
seriously,
My pleasure.
we're in awe at all of the things that you
Yes.
pointed out to us.
Thank you.
Yes.
But to our viewers, we want to thank you for watching. And please, if you have any questions about
Picture?
the whole estate planning and asset protection issue, please let us hear from you, and we'll be sure to get our guests the information and be able to get back to you. And again, let us hear from you if you have any other feedback, any other ideas for topics for our show. Because remember, this is your show, the law, your money, and you.